Hi, everyone. Welcome and thanks for joining us. My name is Robert. I'll be not really your host, more your MC today. My good friend Edward is going to be our host and going to take us through the program. We're going to get started in just a few seconds. Bear with me for a moment. Just setting up some last minute things. Okay, let's go ahead and get underway. Happy Sunday, everyone. Thanks for joining us. I'm going to turn things over to Edward and let him take it away. Edward, it's all yours. Take as long as you need. This program is being recorded. If you end up having to drop off for any reason, there will be a recording of it available on our YouTube page, either later tonight or sometime tomorrow. And with that, I want to welcome my good friend, Professor Edward. Take it away. It's all yours, Edward.
Hi, Robert. Hi, everyone. Thank you for spending some time Sunday afternoon with us. Yet again, another difficult topic, and I constantly am thankful and impressed by the persons who join us for this learning. There are two axioms that I think about. Number one, every one of us in listening here has been in a position where laws exist to protect us, but they have not. That's the first axiom. Excuse me. And the second axiom is enslaved persons are not born that way, they are legislated that way. The topic that I'm looking at this evening is called legal. The laws and social practices, the one support the other, of US apartheid, making white one law at a time. And what is it that we want to do? This is from the Alabama State Constitution Convention, 1901. Within the limits imposed by the federal Constitution to establish white supremacy in this state. I'll probably spend about 90 minutes this afternoon, maybe a little more. You will see a lot of words go through here, and we're not going to pause on a number of them because it is really deadening just listening to the law. But you can see as we go through some of the practices that we're talking about. Ta-Nehisi Coates, yet America was born on the preferential, beg pardon. If you're black, you're not a person and you're not a citizen. Nell Irvin Painter, The Invention of White. And if one had to ask Ms. Painter how she knew that, one could turn to two Supreme Court documents, 1857 and 1873, and we're going to look at them here ourselves in a moment. Just to kind of go back to where we were 2 weeks ago in white, from free persons, white free persons to the white ethno state. I talked then that it's kind of my consideration that race is a theory of history. So rather than looking at it as biology, I think about it as a theory or a structure or an archaeological way of thinking about how we put our societies together. And at the time, I looked at 4 different topics. How pink people became white, and archaeology. How Jesus became white, European probably, and defended the Confederacy. Jim Crow and apartheid, keeping white segregated. What is the function of white? And lastly, the 51st state of Jefferson, occurring on right this moment, or making America white again, practices of supremacy. Looking at today, definitions, segregation and apartheid. We'll talk a bit about how that is. And we talk a little bit about the rule of law, and already I've talked about axioms, how laws are supposed to protect, but laws defend the powerful, so that the law that protects you might have somebody else with a more powerful law. We'll look at post-independence, white laws, and I call them that for a reason. We call them Jim Crow, and I don't think we ever refer to them as white laws. And so we don't realize that these are laws. These are structural apartheid. They're terror enforced. Practically white. How to be white in practice. We'll talk about whitening up in public or white cased. Apartheid in the 20th century. States' whites. Which states have whites in the Constitution and why? The color of the law, which is, as my counselors here will know, a legal expression. Back to the beginning, the Declaration, the Constitution, the Supreme Court, and even going on now from Wilmington 1896 to the Proud Boys in 2016. Okay, here's where we go. Top to the left and the right, you see a waiting room for whites only by order of police. We hear that referred to as Jim Crow, and probably everyone has seen a number of these images this evening before and previously, and that they're fairly commonplace. And I don't want to necessarily show them again, but I wanted to put them into different contexts. The sign on the left, on the right, is South African. It's also for white people. These public premises and the amenities thereof have been reserved for the exclusive use of white persons by order of U.S., South Africa. Exclusively for white people. You'll be pleased to know that maximum of 5 colored customers, BOH staff accepted, and this is in Texas, city of Austin. It says sponsored, but probably means law. Also Texas. This park was given for white people only. Mexicans and Negroes stay out, by order of the park board. And I should say about that particular sign, you will see versions of that and a whole variety of persons are included. So these particular different signs, you can take out whatever character or ethnicity is in the sign and then go to a different one and you will see, you can find signs for that. So the things that people say, quote, the Bible gives authority for segregation, close quote. And we just don't want our children to go to school with Negroes, quote, end quote. A little higher up the food chain, this is a white man's country and will always remain a white man's country. Associate Justice James F. Byrne, Supreme Court. As high up the food chain, there is no case in history where the Caucasian race has survived social integration. We will not drink from the cup of genocide. This is white man's country. President Johnson, Lincoln's successor. Senator Stephen Douglas, 1858. This government was made by our fathers on the white basis, made by white men for the benefit of white men and their posterity forever. Quote, I will say then that I am not, nor ever have been in favor of bringing about in any way the social and political equality of the white and black races. That I am not now, nor ever have been in favor of making voters or jurors of Negroes, nor of qualifying them to hold office, nor to intermarry with white people. And I will say in addition to this, that there is a physical difference between the white and the black races, which I believe will forever forbid the two races living together on terms of social and political equality. And inasmuch as they cannot so live, while they do remain together, there must be the position of superior and inferior. And I, as much as any other man, am in favor of having the superior position assigned to the white race. I say upon this occasion, I do not perceive that because the white man is to have the superior position, the Negro should be denied everything. I do not understand that because I do not want a Negro woman for a slave, I must necessarily want her for a wife. The speaker of that, Abraham Lincoln, 1858. In the same debate as Steve Douglas. So we may find these quotes offensive, embarrassing, but there's legal precedent for all of them. 3 of them were judges, 1 of them was a president, and 2 of them were courts. The 1705 Virginia Code, in essence, anticipates and provides justification for the Supreme Court Dred Scott decision. In 1857, a decision which you've heard me talk about it before if you've been on these which should be mandatory reading for all of us, and it never is. The Dred Scott Supreme Court decision rules this: Black people, whether enslaved or free, came from a slave race. These are paraphrases, and we'll get to the text itself in a moment. This made them inferior to white people and therefore incompatible with American democracy. And going back a slide to the Abraham Lincoln citation, which astonishes some people, astonishes me, as a matter of fact. Mr. Lincoln, like many persons of his time, had to do a lot of mental reorganizing of the furniture to understand that he was called to a different world. But he says something in that quote about that being the differences that there are between races, and he used this in the 18th century, 17th century expression, that they cannot live together without something happening to one or the other. He's quoting practically Jefferson here, and we're going to talk a little bit about why Jefferson becomes so important in all of this. So first, definitions: segregation and apartheid. Hold on one second. We're going back. Apartheid, as South African English, was a system of institutionalized racial segregation that existed in South Africa and Southwest Africa, Namibia, from 1948 until the early 1990s. 1948 until the early 1990s. Characterized by authoritarian political culture based on white supremacy. Ensured that South Africa dominated politically, socially, and economically by the nation's minority white population. And according to the system of stratification, white citizens had the highest status, followed by Asians and coloreds, quote, quote, and then Black Africans. The economic legacy and social effects of apartheid continue to this day. And broadly speaking, apartheid was delineated into petty apartheid, entailing the segregation of public facilities, social events, and grand apartheid, dictating marriage, school, housing, employment, opportunities by race. So we say, how is this different from the US? In basic principles, apartheid did not differ and does not from the policy of segregation of the South African governments existing before the Afrikaner National Party came into power in 1948. The main difference is that apartheid made segregation part of the law. The United States racial history has aspects that are different than South Africa's. It involves not only the indigenous First Peoples, Native Americans as we know them, but also Black Americans, slaved and unslaved, their descendants, Asian immigrants, Mexico, indigenous people of different parts of America. We are well aware as we listen here this afternoon of the civil rights struggles of Black Americans to achieve equality, but much more unfamiliar with the struggles of America's First Peoples, Jewish, Mexican, Asian, and even the Irish immigrants to achieve an equal place. And I should say, for my purposes of usage, I do not use African American unless I use the expression European American, because as a European American, to go silenced and to point out an African American is to suggest that I, in terms of being a white person, am still at the center of the circle. So if one is going to make a comparison linguistically, one should say one or the other, Black or white, if we're going to use that prescription. But so nonetheless here, the worlds are legally cognate, as we'll see. In South Africa, the first apartheid laws were the prohibition of mixed marriages, 1949, followed by the Immorality Act of 1950. Together, these worked to prohibit South Africans from marrying or having sexual relations with persons of a different race. That law was passed in Virginia, then a colony, in 1705, and versions were passed by most other states until 1967. The first grand apartheid law, the Population Registration Act of 1950, classified all South Africans into one of four racial groups and made for pass legislation that every citizen over 18 was required to carry an identity card showing their racial group. Starting in 1663, Virginia, most colonies and states later enacted caste marriage laws, and I call them that for a reason, as well as some form of pass permission to move laws. Apartheid was then further implemented in South Africa through the Group Areas Act of 1950, which required people to live specifically in assigned geographic areas according to their race. We know that in the United States as redlining. In South America, the law said the highways and railroads were clearly designed to create spatial division between racial groups. The expression in the United States, the other side of the tracks. And what we may not know here, unless we have tried ourselves to acquire a mortgage, and we find out that where we live, perhaps the color of our skin, perhaps all sorts of other kinds of factors that do come into it with a slight nod and a wink from the government, a forgotten history of how the US government segregated America. This is the title. It was in something called the 30s Underwriting Manual of the Federal Housing Administration, which said, quote, incompatible racial groups should not be permitted to live in the same communities, quote. Loans to Black Americans could not be insured. The Underwriting Manual of the Federal Housing Administration recommended that highways be a good way to separate Black Americans from white neighborhoods. So we begin to look here. You see anyone disobeying these laws will be imprisoned, fined, or whipped. Under no circumstances can an employer pay Afrikaans the same rate for which persons of another color get. No African may strike for any reason whatsoever, et cetera, et cetera, et cetera. You can read the laws. You can actually find any of this particular material on Google particularly easily. And you'll find that anyone disobeying these laws in the US at different times and places can be imprisoned, fined, and or whipped. The book on the left, The United States and South Africa in the Early Cold War, Apartheid's Reluctant Uncle. The image on the bottom, Mr. Dillon wearing a South Africa flag and the all-white Rhodesia flag. Ruth's Facebook profile shows him wearing patches on his jacket that represent apartheid-era South Africa and the unrecognized but white-dominated state of Rhodesia. So just to pause, so the suggestion that I'm making here is the apartheid legislation in South Africa mimics, only it's simply later than the varieties of laws that we're going to see here in the United States. And it's only that we call it segregation. So the point that I'll be making this evening is that we are segregating white people. We're not segregating African Americans, Black Americans. The apartheid that is in place and still in place, even if it has not been formally disallowed. Population registration and segregation, job reservation, economic apartheid, segregation in education, sexual apartheid, land tenure and geographic segregation, passed laws, political representation. I live in a state that has no political representation for the reason fact that it was designed to be an enslaved position of power demonstrating Southern power to the state, whatever else they want to say about it. Separate development, banning detention without trial in states. That image in the front, by the way, and in the center is the, quote, colored sailors rec room for the 250,000 sailors who basically served on the US side in the war. So segregation as practiced in the US is a euphemism. It distanced those with the power to establish it from the effects. It's the effect of being in a place that a law exists to protect you, but it does not because someone else's law is better than yours. It's a legally enforced system of apartheid. We are not segregating that other population. The intention of these laws was to segregate ourselves from them. For the same reason that to call Jim Crow and not to say that these are laws, whoever thinks about this? This is part of the legal code, passed and in some cases repassed and approved and underwritten by the Supreme Court of the United States. Chief Justice Roger Taney, March 6, 1857, quote, no African American, free or enslaved, had ever enjoyed the rights of a citizen under the Constitution. Quote, Justice Taney argues, since the time of the ratification of the Constitution, blacks had been, quote, regarded as beings of an inferior order, altogether unfit to associate with the white race, and so far inferior that they had no rights which the white man was bound to respect. This is a Supreme Court decision. Colonialism was legal. Enslavement was legal. The Holocaust was legal. Jim Crow law was legal. Apartheid was legal. Well, a takeaway from this evening is that legality is not a matter of power, or is a matter of power, often not a matter of justice. Nor is it limited to the South, despite the popular American mythology of memory that says that the era of Jim Crow, where Southern statutes enforced the strict separation of races, and again to say the strict separation of white people away from contact with other people, and restricted the rights of black people. Northern Protestant as well as Catholic churches remained largely apartheid, segregated, and muted in their criticism. Many white Christians, as we have seen in the quote, saw segregation as simply part of God's plan for humanity. The Bible gives authority for segregation. Quote, we just don't want our children to go to school with Negroes, close quote. This image, 1921, Oregon. Apartheid, segregation, white-cased systems of power. Laws collude with practices, but they control practices beyond them. Racially and ethnically structured institutions and manifestations structure apartheid. In addition, racially and ethnically structured institutions extend far beyond the legal sanctions of enslavement and apartheid, and far beyond the limit of any specific ethnicity or race. Hip hip hurrah, Chinese excluded. What law are they talking about? There are two or three that they could refer to. It might refer to the 1870 Supreme Court law in California that said that, quote, Chinese persons cannot bring suit against white persons because nature has intended them to be of a separate and lower order. So in US practice, these have included what I'm calling kind of a soft form of genocide. Assimilation, cultural erasure, quote, perhaps for their own good, and probably many of us listening have been in situations where someone says to us, this is for your own good, and I usually say, run like beep, because something terrible is going to happen. Enslavement and segregation in Native American and indigenous First People reservations. I taught at a school in Phoenix, Arizona, right next to the Indian school, what they called them. And you've been seeing a little bit of that in the news lately of mass graves that are being found on premises. The First People's boarding schools, immigration, naturalization laws, internment camps, Asian exclusive, Japanese internments. We have not been good with our people. And the larger point of what I'm making here is that this being not good started very early on and was written actually into our very first laws, as we'll see. The Indigene who preceded the colonists fared as poorly, and their history is often erased. Excuse me. So Woodrow Wilson, white supremacist, segregationist of the District of Columbia, which since 1790 has been and continues to be a show of slaver power. I'm just throwing this in here because I'm having a bad Woodrow Wilson day. I went out on a walk today, and there's a school nearby, which is largely Black American residents of the neighborhood who live there, named Woodrow Wilson. I'm saying, why do we still have that name here? This man has a bridge named after him, and the bridge, when it was built, goes it debauches ends into, I'm going to say that I won't call it a burial ground because these persons, these black enslaved persons, were not buried; they were dumped in Virginia. There's no markers. You can Google this. You can at least Google where the map where it is. This is in Griffith's Birth of a Nation. He quotes Woodrow Wilson. The white men were roused by mere instinct of self-preservation until at last there had sprung into existence a great Ku Klux Klan, a veritable empire of the South, to protect the Southern country. There's a little bit going on here, and I will say that Woodrow Wilson defends the Ku Klux Klan, but the Ku Klux Klan as a social practice can only happen where there are laws that exist to protect it. So that Woodrow Wilson, the legalist, who, while he was also fighting World War, took the District of Columbia and segregated it. The power of words, what we're talking about here in terms of law. Pre- and colonial laws governing citizenship and whiteness. From the very first, it was a question of the law. White is a matter of law, not biology. Slaves are not born, they're legislated. We talked about that a moment ago. Virginia takes the lead, and you're going to hear me going on about Virginia. In some ways, Virginia was the first place to do a lot of it. And the first thing to understand is that the British law and background and history did not provide a legal structure for enslavement. It wasn't part of the, at least in terms of the British nature, so that when Nathaniel Hawthorne talks about the Scarlet Letter, when he talks about an A actually burned into the chest, or at least into, he's being nice about it. This was in the 1547 Tudor laws of vagrancy, and those laws went away pretty quickly. But Virginia is taking the lead to make white the part of the law, and also the first to make it white a legal record. And one of the first recorded histories that we're going to be talking about here, I'm going to ignore the first part, is John Punch in 1636, who escapes from his white master as a servant with two other servants, Europeans. So the European servants and the black servant, they did not call him a slave at the time, they were all captured and brought back. They went to law. The two European servants were given 3 extra years on their term as servants. John Punch, obviously a made-up name for the African, is called a slave and extends to serve his master for the time of his vita durante, his natural life. And John Punch, by the way, has ancestry that connects him, oddly enough, through Obama's white mother. Throughout what you're going to be seeing here, the slides in kind of this color here are going to be laws that are passed specifically around enslavement. In 1641, Massachusetts becomes the first colony legally to recognize enslavement in the oddly named Book of Liberties. Other states, such as Virginia, follow. In 1662, Virginia decides all children born in a colony to a slave mother would be enslaved. Why is this? Because, as a matter of fact, if they followed the condition of the father, they likely would have been the children of the plantation owner. I don't mean to put it that directly, but I probably should. Enslavement was not only a lifelong condition, now it could be passed like skin color from generation to generation. The Royal African Company in 1660, the Duke of York, we know now as New York, James, the brother of Charles II, English suppliers responding to increased demand for enslavement. So the royal family officially starts the slave trade as the King of England charters the Royal African Company. This is fascinating reading if you want to do it. I won't take a lot of time here. But James, the Duke of York, well, we know New York, from which we get the stock market, establishes New York as the center of enslavement, second only to Charleston. New York, 1788, catch the dates. This is the year before their actual ratification of the Constitution. So when they say that the North had nothing to do with this, well, an act concerning slaves, being Chapter 40 of the laws of that year, a revision of the existing laws of the state relating to enslavement, the first deliberate expression. It says, every Negro, mulatto, or mestizo within the state who at the time of the passing of this act is a slave for his or her life, they shall continue such for and during his or her life, unless he or she shall be manumitted or set free in the manner prescribed in and by this act or in some future law of this state. This is New York, 1788. Sorry. Still, like White, the issue of who was and who wasn't a slave seemed never solved. 1670, this is Virginia. Some dispute have arisen whether Indians taken in war by the nation and by that nation that take them sold to the English are servants for life or terms of years. So you see here, very early on in the beginning, they're trying to sort out what's a slave, who's a slave, is that a servant, how long? They have for biblical warrant the 7 years from the book of Deuteronomy. And that servants not being Christians imported meant that they could be enslaved. 1682, Virginia changes the law and says, well, even if they are baptized as Christians, they still can be enslaved. And be it further enacted that anybody brought into the country by sea or land, whether Negroes or Moors or mulattoes or Indians, who and whose parentage and native countries are not Christian at the time of the first purchase, etc., etc., etc. So what you see is that there's a greater and greater need to parse repeatedly just exactly who they're talking about, what they're talking about it, in the same way that, in fact, if you go to Supreme Court documents on ethnicity and you look at the way over the years who becomes white, how do they become white? Since the end of the 19th century, different persons, the cases are brought to the Supreme Court by various different ethnicities arguing that they are white or they're not something else. But so that in general, the practices, casual and ad hoc, of apartheid harden and simplify, not to the credit of those in power or those over power. In red, 1705 to 1776, from White in Virginia, which defines, quote, Negroes as real estate, quote, end quote, to 1776, the 13 colonies passed probably 50 to 60 laws defining and governing the enslaved. From 1777 to 1865, the states passed approximately 200 laws defining and governing the enslaved. So again, we know the story of the Constitution that's taught us in grade school and high school and college. The Constitution was a compromise. I call it, yes, the compromise Constitution, because the quote, institution of slavery was going to die out in 20 years. As we can see, not only did it not die out, it quadrupled from 700,000 enslaved persons in 1790 to 4 million at the 1860 US Census, and that's a census number. Now, I'm not going to read these slides, but you can see them all. These are all of the laws that are made and constantly made. New York, Connecticut, Massachusetts, New York again, Rhode Island, Pennsylvania, Charleston, Maryland, New York, Virginia outlaws manumission. French Louisiana, 1724, prohibits slaves from marrying without the permission of their owners. 1730, the number of male and female slaves imported to the North American British colonies balances out for the first time. 1731, the Spanish reverses 1730 decision. Slaves fleeing in Florida, which was then Spanish property, will not be sold in return. 1732, 33, 35, French, Quakers, New York, Virginia. The Virginia House, sorry. I want to go back here to this slide here. Slave laws, aka non-European case protection laws, the question of marriage. What is the thing with marriage? We'll talk about that. 1682, the burgesses of Virginia pass a law limiting citizenship to Europeans. It makes all non-Europeans, Negroes, Moors, mulattoes, and Indians, as the law put it, quote, slaves to all intents and purposes. In 1705, in the 1705 Virginia Slave Code, and if you're taking notes and want to look that up, that's what it's called, you will see Negroes, Moors, mulattoes, and Indians are not only do they call them slaves, they call them real estate. Virginia was giving away land at the time in 50-acre allotments, but only to Europeans. Why is this important? The first Naturalization Act in 1790 would follow this precedent. This should not surprise us. 8 out of the first 12 presidents of the United States were Virginian. This should not surprise us. The federal government was moved from New York to Pennsylvania down to where it is now at the corner of Virginia and Maryland. Both of these are slaver states. It was moved there for a reason. 9 years later, in 1691, the Burgesses passed another law. For probably the first time, uses the English-speaking colonies of the word white rather than English, European, or Christian, which is what probably folks most would say. Right. The law reads, quote, whatsoever English or other white man or woman, one of the very first times a woman is mentioned in here, because it refers to marriage, being free, shall intermarry with a Negro, mulatto, or Indian man or woman, bond or free, shall within 3 months after marriage be banished and removed from this dominion forever. Just a side note, you remember that when same-sex marriage in Virginia was passed, in Massachusetts in 2004, when my husband and I were first married, Mitt Romney was using this law to try to back away, to try to pull the rug out from underneath the Massachusetts law. 1705, this is the law I want you to see. All servants imported and brought into the country who are not Christians in their native country shall be accounted and slaves. Now, again, a little bit later, they're going to say that even if you are a Christian in this country, you still can be a slave, which cuts from thousands of years of Christian tradition. All Negro, mulatto, and Indian slaves within this dominion shall be held to be real estate. A pause. You've heard me talk about the 1619, that date, and my issue with that particular date is the point that you're making over here. This is 1705. Indian slaves, the enslavement of the first peoples in the Americas extends historically back 400 or 500 years, 600 years. And from the time of Columbus, 1495, through 1619, you had probably 500,000 first people, Indian slaves, on the East Coast area alone. That's part of the narrative that we need to be brought back in. If any enslaved resists his master, correcting such slave, and should happen to be killed in such correction, the master shall be free of all punishment, as if such accident never happened. Oops. These are the laws. All right, I'm not going to go through here, but I want you to just look at the date. 62, 67, 69, 70, 72, 1680, 82, 891. 1691, Virginia votes to banish any white man or woman who married a black, mulatto, or Indian. We saw this in 67 when the Supreme in Loving versus Virginia. As a Virginia clergy person, I go in. Any clergy person who wants to do a wedding in Virginia has to go in and be registered in the courts still. And they have you fill out a form, and it says, "I have seen the bride and the groom." The point is, it's 1968, and you can't say race prohibited, but you can say it visually. That's according to the law. 1662, declared free or independent. 1680, slaves to have a pass. 1682. So, defining whiteness was not an end to it. Policing the line is, you see on the right, place of birth, husband, father, mother, okay? Race. A white, and then down the asterisk, a white person is one with no trace whatsoever of blood of another race, except that one with 1/16 of the blood of American Indian, etc., etc. It's tedious and depressing to read this. And this is Virginia, and we can say what we want to say about that. It is certainly not alone that Virginia's precedent. What we can say is that Virginia was the colony that was having to do the footwork on a lot of this, because at the particular point, there were fewer colonies at the time who had the kinds of resources that this was possible. Being enacted by the General Assembly that every person whose grandfathers or grandmothers of anyone is or shall have been a Negro, although all his other progenitors, except those descending from the Negro, shall have been white persons, shall be deemed mulatto. Remember that the woman enslaved by Thomas Jefferson, Sally Hemings, who came to him as a child as part of a dowry for his wife. She was 3/4 European. So every person who shall have 1/4 part or more of Negro blood shall in like manner be deemed a mulatto. The first one-drop case law begins in Virginia. In this century, health official Plecker led the effort to purify the white race in Virginia by forcing First Peoples and other non-whites to classify themselves as blacks. It amounted to bureaucratic genocide. And you can still see that today in the law. Plecker championed legislation that would codify the idea that people with 1 drop of Negro blood, quote, could not be classified as white. His efforts led the Virginia legislatures to pass the Racial Integrity Act of 1924 that criminalized interracial marriage and also required every birth in the state to be recorded with the only options being white or colored. The first part, criminalizing interracial marriage, that had been since 1705. That was not a new thing. But we see that in Oregon, we see that in California, you'll see that in Connecticut, you'll see that in Massachusetts. It is not alone to Virginia. Okay. What's interesting to go back to the early centuries and to think about the eugenics in the United States and to think about the same sorts of things that were happening in the early Nazi regime and the work up to in the Weimar Republic in Germany, and how similar and how much the Nazis learned from, and this is, again, I'll be doing something like this in December, but you can, the evidence in terms of the Rockefellers and the philanthropists of the East Coast who were providing resources for German institutions to consider eugenics and racial purity. Our language of breeding, for example, and we talk about our fetish on dog breeding. It comes out of this. Eugenics certificates that you would have gotten to be married. Plecker was proud of the law, his role in creating it. He says it's the most perfect expression of the white ideal and the most important eugenical effort that has been made in 4,000 years. To which Adolf Hitler will remark in his Mein Kampf that the work of civilization is essentially about purifying the race. Uh, 1779, again the date. Virginia obsessed about who is deemed citizens of the Commonwealth, being enacted that all white persons born within the territory of this Commonwealth, etc., etc., etc. It does not surprise us that less than a year later, the first Naturalization Act will be open to by the new Congress, months after it was ratified, free white persons of good standing. You're going, white standing? What is this? So moving on, you sort of see the point that by 1750, black enslaved were not legally permitted to do pretty much of anything on these early codes. These are early. Enslaved had virtually no legal rights in most areas that could be executed for crimes that were not capital offenses. Their testimony was restricted. Trial of enslaved were usually by special courts. Slaves could not own property, move about with consent, or legally marry. This is apartheid. All right. Jefferson. What does Jefferson think about this, Bill? I want to come back here. Sorry, having a what do they call it, an internet moment. All right. Jefferson is important, and these are remarks that are going to talk about his notes on Virginia. About the 1779 Jefferson remarks. That although the amendment is described by Jefferson was undoubtedly in advance, he says that, quote, making allowances for the difference of condition of education and conversation, quote, the Negroes were an inferior race. Quote, the improvement of the blacks in body and mind in the first instance of their mixture with the whites has been observed by everyone and proves that their inferiority is not the effect merely of their condition of life. And three, this is what you heard Lincoln a moment ago, quote, deep-rooted prejudices entertained by the whites, quote, and, quote, 10,000 recollections by the blacks of the injuries they had sustained, end quote, could never live in freedom and harmony together under the same government, and if it were attempted, would, quote, produce convulsions which would probably never end, but in the extermination of the one or the other race. Why is this important? Because Jefferson is the poster person for all of the 19th century, mostly around Confederates, and they would take what he had to say about this as law. The question then comes down to, so we're sorry, I'm going to go back here again. So this is Virginia. One asks, in what kind of culture, apartheid culture, segregate, what kind of culture do we notice things? So here you have a person who goes on to become a governor and who's a medical student, and you have persons posing, not caught randomly, but on purpose, dressed a certain way to evoke, mimic. You say, well, it's meant to be comic. Well, comedy usually references some kind of anxiety, which is why there's laughter around it. But in what kind of culture can carry you back to old Virginia, a racist minstrel tune, still be recognized as the state's song emeritus? White laws in the new nation, 1790, 20 to 21. Remember that in the first words on this subject, Congress in 1790 restricts naturalizations to white persons. We've seen Virginia's example, and that's no surprise. The South controls the location and the tone of the Constitution and the aftermath. The requirements for naturalization changed frequently thereafter. The requirement for being a white person stayed in effect until 1952. And from the earliest years of this country until just a generation ago, being a white person was a condition for acquiring citizenship. Okay, so here's the laws again. Same drill as before. The 84, Jefferson, North Carolina, New York, Virginia, Delaware, South Carolina, North Carolina, New York. 1817, 1819, 1819, 1819, 1820, 22, 1831, 1832. Britain abolishes slavery in all its colonies, effective the following year. 1834, New York City and Philadelphia, Pennsylvania, experienced riots against blacks and anti-slavery advocates. 1837, blacks in Pennsylvania and Mississippi. 39, 40.
Hi, everyone. It looks like we had a technical problem with Ed. Just sit tight and he'll be back on in just a second. Hi, everyone. We're going to get started back up in just a second. Edward, our host, had some technical problems, but he'll be back online in just a second. Just sit tight. While we're waiting, I posted it before. I'll do it again. I'll post the previous programs that Edward did in the chat if you want to watch those at your leisure. They're on our YouTube channel. So we'll be back online in just a couple minutes. If you need to grab a snack or a beverage, now would be a good time to do so. And I'm chatting with Ed via the phone, so he'll be back on in just a second. It's funny that we had a technical problem because sometimes in our programs we take an intermission. So this will be our unscheduled intermission, but we'll start back up in just a second. Ed's communicating with me via text, and he'll be back online momentarily, so just sit tight. While we're waiting for Ed to return, if you have any questions or comments for our program for Edward, he answers those at the end. So if you have any questions or comments on things that you want to know more about or weren't clear or want some additional information on, feel free to type those in the chat or the Q&A, and Edward can take a look at those when he gets finished. Okay, Ed's trying to get back on now, so sit tight. We'll be there hopefully shortly. It's taken a second. He had to reboot his computer, but stand by. We'll be back online in just a minute. Okay, let's see what's happening here. Okay, he's not back just yet. Okay, I have an idea to pass the time while we're waiting. Why don't I do this? I can tell you about what's going to be coming up in the future while we're waiting for Edward to get back online. So let's see, here's today. So coming up next weekend, we're doing tours of the Winston Churchill War Room in London. So this is at 3 o'clock Central Time, that'd be 4 o'clock Eastern on Friday. And that program repeats on Saturday. And let's see, also next Saturday, we're going on the Harriet Tubman Underground Railroad journey. You can join us for that. We post our programs on different platforms. This is our Eventbrite page. And let's see, what else do we have coming up in the future? We got doing a tour of Monet's home and garden in Giverny. We do a tour of the African American Museum. The one on Halloween is sold out. There's no more spaces available. We can only accept so many people for each of our Zoom programs. And then we have a repeat of our Colin Powell program. Oh, here's Edward contacting me. Let me see what's going on. Oh, Edward is back. Okay, stand by momentarily. Stop sharing the screen. Okay, we got Edward back. Stand by for 1 second. And here he is.
Can you fix, there it goes.
I can hear you and I can see you.
Okay.
Thanks, Edward.
Give me a second. You can continue nattering.
Oh, so I was just telling people what events we have coming up. So
Well,
let's see.
I'm going to be doing the one on Halloween also, remember, later on.
How much time do you need? A few seconds or?
Maybe, yeah, I'm ready to go as soon as I get it to the place where we were.
Okay, no problem. Take your time.
I do apologize. I don't know what that was about, but.
Oh, no, it's okay. That happens once in a while.
Does it? Okay. All right, here we go. We did this. We went to here. We went to here. We went to here. We went to Jefferson. All right. White laws in the new nation. Remember from 1777 to 1865, the states passed approximately 200 white laws. Robert, am I good? Can you see and hear me?
Oh, yeah. Yep. I can hear you. I can see everything's good. Back to normal.
Right. So again, we're not going to go through the laws, and I apologize for the misconnect over there. But understand that apartheid is legal base, and for 300 years, at least 100, 200 years, there was a great attempt in this particular country to sort out by law the relations between white Americans and black Americans. And I call them black Americans and not enslaved at this particular point, because after 1777, probably most of the persons who were enslaved in this country were actually brought into, were born into the country. In 1860, the slave population is now nearly 4 million, making the ratio of free to enslaved Americans approximately 7 to 1. 1860, Arizona passes an expulsion act, banishing all free blacks from the state. 1861, Texas prohibits manumission. 1861, South Carolina secedes from the Union. There. 1865 through 1967, apartheid law, terror enforced. So after the passage of laws which segregated white Americans from black, the people negatively affected by these laws, white as well as black, saw no progress in their quest for equality. Racial segregation was not a new phenomenon, as illustrated by the fact that almost 4 billion blacks had been enslaved before the Civil War. And I say that white as well as black saw no progress because the expression grandfather clause, we saw this just a moment ago, where grandfather and grandmother, where they would track back to your forebears to figure out how to handle the law with you. And in terms of voting, that even if you were illiterate, when in the 1890s Mississippi began passing poll taxes and literacy taxes. If you were white and illiterate, if your grandfather could vote, so could you. But after the war, the laws passed segregated white Americans from blacks in order to enforce a system of white supremacy. It ensures this through legal means. This is where the word apartheid functions. Signs were used to show non-whites where they could legally walk, talk, drink, rest, or eat, and even how they would play, as we'll see. For places that were racially mixed, blacks had to wait until all white customers were dealt with. And Dr. Martin Luther King observes that the only department in a department store that black consumers could not use was the waiting that would have been the dining room. Rules were also to enforce restricted African Americans from entering white stores, white-only schools to white-only graveyards. Others, often blacks, were refused mock burial anywhere. New York, Holy Trinity, Georgetown. I mentioned the burial ground of the Virginia enslaved, which is now the base where the Woodrow Wilson Bridge sits. This is Ta-Nehisi Coates. 250 years of slavery. This is what we were talking about. In red, 90 years of Jim Crow, 60 years of separate but equal, 35 years of racist housing policy. I put this in red because there is some debate among what here is why should I pay reparations, or why should we do any kind of restorative justice after enslavement, because enslavement ends in 1865, because these other things don't end. And the 90 years of Jim Crow is Jim Crow segregatory cased law. 60 years of separate but equal. They are not equal, and we can figure that out. 35 years of racist housing policy. This, all you have to do is go to the FHA and look at their records and look at their underwriting manuals. So he writes, until we reckon with our compounding moral debts, America will never be whole. This is an important stateless from 1857 through 1870. Black Americans were effectively stateless and law deprived. The black-white divide, parceled out painfully law by law, parsed out by law, is written into law and from there intercultural habit. Written into law, practiced out in practices of exclusion and violence. The war between the states, the Civil War, ends in 1865. 1865, Amendment 13 to the Constitution abolishes enslavement throughout the country. 1865 through 66, Mississippi and other Confederate states enacts black codes to counteract the 13th Amendment. And you will see the counteraction. You will see the Supreme Court actually take down these laws, the amendments, for this particular reason. Amendment 415 in 1969, ratified 1870, 5 years following the war between the states. So datum, for 5 years, Black Americans had no legal protection, actually 13 years if dating from Dred Scott in 1857. And the area that we're going to be talking about now here is how race-centered conflicts in the U.S. and what happens what we do with that. In one of the other presentations that I've had the privilege, thank you to Robert, to host on here, is to talk about how we think about enslavement narratives. And it's like, so we want to read about how slaves like Jim Brown and how all these folks managed to escape Frederick Douglass. And when we change the topic, when you look at it, there are actually more race-centered U.S. conflicts after the ending of enslavement than there were before. 1865 through 1877, 24 race-centered conflicts in the U.S. Some equally important dates, race riots, as they call them, usually they're massacres. The Ku Klux Klan is founded. Congress gave blacks the rights to vote in D.C. That's rescinded a little bit later. Howard University in 1867 is really probably the first act of reparation that's done by the Congress. 1868, the 14th Amendment, 15th Amendment in 1870. Okay. White-initiated violence, race terrorism supported by law. There's no other way of saying that than calling it race terrorism supported by law. It's apartheid. A headline, white line violence spreads to Mississippi in 1875. Difficult to differentiate clans from similar groups, and probably you may or may not know these names, the White Line, the Redemptorists, the Knights of the White Camellia, the White Brotherhood. The distinctions don't matter, but such groups were part of a web of terror supported by law spread through the South during Reconstruction. The Vicksburg Massacre, violent white mob massacres black citizens at political meeting in Mississippi. This is 1874. The Clinton riot. What's interesting here, they call it a riot when it was actually attended by more than 1,500 blacks and about 75 whites. 300 plus blacks are killed and 3 whites. The violence serves as a pretext for the return of white rule in the end of Reconstruction in Mississippi. Redeemer Nation in 1868 with Amendment 14, the Constitution gives black persons full citizenship. Blacks voted, one elected, served on juries. 10 years later, federal troops withdraw from the South, returning it to the local white rule. And at this point, the Redeemers come through. This is a fairly famous book that any American Studies student would know and have read. And it looks at how Christian imagery is used in the myth of America. And what I find completely tone deaf about it is why, for the use of Redeemer governments in the South, And that redemption governments, talk about the Democrats that, as we knew them then, described their return to power between 1869 and 75. They recapture southern state governments, Alabama, Arkansas, Georgia, Mississippi, North Carolina, Tennessee, etc. The political deal made during the national election of 1876 marks the end of Reconstruction when Rutherford B. Hayes takes office in 1877. And Tilden Road, a few blocks from where I'm having this conversation, reminds me every day of the compromise of that. So, in the former Confederacy, when the cartoon calls white primary, so the governments were endlessly inventive in how they could. You see this even today in the way the abortion laws and providers of abortion laws and the mechanics and the structure around how the laws are being parsed so that the laws themselves become unchallengeable, as is happening in the law about Texas. The same kind of ingenuity was used to actually dismantle peg by peg what they would call the Reconstruction Amendments 13, 14, and 15. In the former Confederacy and neighboring states, local governments constructed a legal system aimed at reestablishing a society. Black American men were largely barred from voting. You've seen, we'll talk about poll taxes, you talked about literacy, legislation known as Jim Crow laws. Jim Crow is law, it is not practice. Separates people of color from whites in schools and housings, jobs, and public gathering places. More accurate to say, separates whites from those persons. And denying black men at this particular time the right to vote through legal maneuvering and violence was a first step in taking away civil rights. Literacy tests, poll taxes, elaborate registration system. The literacy test, again, that's where the expression grandfather clause comes from. That even if you were illiterate, and if you were white, if your grandfather voted, you could vote. Eventually, whites only Democratic Party primaries to exclude black voters. So here you have Uncle Sam, and here you have the South. Well, we're just having a white primary. Nothing wrong about that. 1958, this man arrested outside a court where he goes to support Rosa Parks. Martin Luther King, Dr. Martin Luther King, then a medical student, then a theological student. He's arrested on vagrancy laws, which essentially gave any marshal, any sheriff, any police person the power to move any black person they wanted, when they wanted, away from where they wanted them to be. So the laws were not just theoretical. Race assignment weaponized. Racial violence in the Reconstruction period took three major forms. And I apologize for repeating a lot of this. I want to put it in the context that what we would call urban riots, the interpersonal fights, organized vigilante groups, and usually white person vigilante groups. The most notable were riots, conflicts in Memphis and New Orleans in 1866, large scale in places outside South Carolina and Colfax and Louisiana, New Orleans, Yazoo, Mississippi, Hamburg. And the death toll of these conflicts remain incalculable and victims overwhelmingly black. Legal authority was involved in all. Tulsa, for example, the white mob was deputized by the white sheriff. At least two of these were coup, removing legitimate authority. You're going to hear me talk about Wilmington. From 1866 to 1912, 55 loss of life events in urban places, north and south. Remember, there were 24, 1867 through 1870, 1872. 55, double from 66 to 1912. New Orleans, Memphis, Pulaski, St. Bernard Parish, Louisiana, Georgia, Rhode Island, Utah, New York, South Carolina, North Carolina, New York City, Meredith, Mississippi, New York, Los Angeles, Scranton. Again, Louisiana, Mississippi, Battle of Liberty Place, New Orleans, Mississippi, South Carolina, Hamburg, Ellington. Where are we in school with any of this material? Do we ever see it? Do we ever see any of this? On this site occurred the Colfax riot, in which 3 white men and 150 Negroes were slain. Wow. Do we know their names? Probably not. Why do they call it a riot? It was initiated by the white mob. 62 to 153 black militiamen were killed while surrendering to a mob of former Confederate soldiers and members of the Ku Klux Klan. Killed while surrendering, you may recall Sitting Bull in 1890, who was likewise in custody, in federal custody, and he was killed by the police, by the reservation police while in custody. So the last thing you see is 3 white men also died in the confrontation. Great. Again, it goes on and on and on. Age 69, 70, 71, 71. Redeemer government. Freedmen's Bureau, now back to DC, is abolished. They gave home rule to DC for 3 years, and then after that they abolished it. Amnesty Act removes most remaining restrictions on Confederacy office holding. Whites in Virginia, North Carolina vote in Redeemer governments. Whites in Florida vote in Redeemer governments. The recollection of former slaves in Kansas, called the Exodus movement, begins. So not only are we moving the first peoples from Georgia, we're moving former enslaved to Kansas. Within the year, 30,000 blacks migrate to Kansas, actually are migrated. 1881, Tennessee passes the first of its Jim Crow laws. All right, it's between 1880 and 1910 you begin to see what we now call Jim Crow, because what the understanding is from this particular point, the terror has done what it had to do. It essentially returned the Democrats back into power and government, but now they're going to legalize it using the law. And if I mention January 6, 2021 in this particular context, I might be committed to doing that. 1873, Arkansas voted in Redeemer governments, 1874. Here. The Wilmington Insurrection of 1898, better known as the Massacre, carried out by white supremacists in Wilmington, North Carolina. And you say, I lived in North Carolina, I went to school too. Why did I not know about any of this? Well, the white press in Wilmington originally described the event as a race riot caused by blacks. As more facts were publicized, it became to be seen as a coup d'etat, the violent overthrow of a duly elected government by a white group of white supremacists. In 2005, Wilmington put out a 500-page white paper on this with an apology, but no reparations. The white mob put out the White Declaration of Independence, which stated, quote, "We will no longer be ruled and will never again be ruled by men of African origin." A book alike, Democracy Betrayed, 2000. Quote, "What happened in Wilmington became an affirmation of white supremacy, not just in that one city, but in the South and in the nation as a whole. It affirmed that invoking whiteness eclipsed the legal citizenship, individual rights, and equal protection under the laws that blacks were guaranteed under the 14th Amendment. As we will see, the Supreme Court eviscerated those 3 amendments by saying essentially that these were federal amendments, but they did not have anything to do with states' rights. Practically white, how to be practicing and how to be white. White laws and what we are hiding when we call them white lies. Most of us know this. I'm going to pass on pretty clearly, but these are laws that are de jure separation, a legally constructed and socially mandated caste system imposing white separatism. The Reverend Dr. Martin Luther King was in India, I think it was in 1953, and he was visiting Gandhi's memorial. And he turned to one of the Dalits, the Untouchables, and they were having a conversation, and the Indian said to Dr. King, "Well, you must have the same experience as being one of the Untouchable case in the United States." And Dr. King looked at him and said, "No, well, we don't have cases in the United States." And he later remarks in one of his books that it was at this particular point that he understood that what this was about was apartheid and a caste system. To the left, a poll tax. To the right, 1838, the Jim Crow songbook that goes back, as you can see, early on. And you want to think of why were the enslaved persons always represented as happy and dancing. Well, if there were 4 million enslaved persons and only 400,000 white and plantation owners, the number discrepancy, one would do what one had to do to represent these persons as, quote, not a threat, or the system not to be threatened. Frederick Douglass makes this particular point. Jim Crow's laws are interlocking. White, colored, Montgomery, Alabama, Selma, Alabama, public swimming pool, no niggers, no Jews, no dogs. You'll see different signs with different ethnicities. Please understand that depending on the location and depending on the year, our names could be on there too. And the point I make about Black Irish in the 1842s, that the reason we have Irish pubs, and not Polish pubs or other kinds of pubs, is because they function the same way that gay bars did. This was a place where the Irish person could go and be safe, and it was known as that. We serve whites only, no Spanish or Americans. It's a Texas sign. I always laugh at the bad grammar on that one. The laws. Jim Crow apartheid law, a legal regime that constantly self-reinforced. 23, Woodrow Wilson, segregated federal Washington, D.C. Drive up and down 95, stop at the Woodrow Wilson roadside stop over there, read the glowing encomium to Wilson. You would never know that this person had thought these things. Princeton is right now in the business of removing his name from their buildings. In 1930, Birmingham made it illegal for a black person and a white person to play dominoes or checkers together. In something like 1865, Georgetown, Washington, D.C. made it illegal for black persons to fly kites. In 1932, Atlanta prohibited amateur baseball clubs from playing within 2 blocks of each other. Oklahoma required the separation of races when fishing or boating. You may recall that it was the mix of a black kid swimming in Chicago, in a Chicago white-only pond, that started the terrible, they call it a race riot, but it was a massacre in Chicago. 1937, Arkansas segregated its horse racing tracks. So apartheid is a constant reminder of power, the power to make the law and the power to violate it. And let me go back to my point about Chicago and apartheid segregation. I come from a background of linguistic clarity, I suppose, and so when we say something like pre-used or under-owned or whatever, however we avoid saying what we're saying, so that when you see race riots, really that's a euphemism for something completely different. So the Jim Crow law expands the race line case begun in 1705. It's paralegal, but it's socially sanctioned KKK and other guaranteed violence of the law. But it also, remember at this time, redirects immigration anxieties and in 1929, finance. So through the 20s and the early 30s. And a point that I'll make when I come back to this from the other regime, the Nazi regime, the Weimar Republic in Germany, and race purity and what that was like, and how much Mein Kampf and says this, and how much Adolf Hitler actually borrowed almost word for word from our own immigration policies in El Paso, Texas. And the point I made last week is that the element to kill people, Zyklon B, in Nazi Germany slaughterhouses was actually tested out by U.S. agents in El Paso in 1920 as a cleaner, as a fumigant. Here you have no Negroes, no Mexicans, no dogs, no Negroes, no Mexicans. I'll be returning in another week up to the Mexica, and we never think about this particular population of persons who, like the first peoples, when we walked into Texas, it basically took half of Texas, half of Mexico, and made it U.S. We had half a population of Mexicans who lost at that particular time, lost their lands, their homes, and they are still not sorted out well in that. Jim Crow laws. Richmond, one could not live in a street unless most of the residents were people one could marry. We will see that come back again in redlining. One could not marry someone of a different race. In 1914, and why is that? Again, if this is cased, exogamy prevents someone from a different race of essentially marrying up into the culture. For example, which is the Caribbean model, where a mixed race person could marry into the culture and then became the mestiza. He became somebody who was both part of the culture and was capable of defending it. In the United States, Virginia never went that way. There was a line. One drop and you were out. By 1914, Texas had 6 entire towns in which blacks could not live. Mobile past Jim Crow curfew. Blacks could not leave their homes after 10 p.m. To this day in North Carolina, you can drive down the streets and you can go from, let's say, Durham, North Carolina to the beach towns, and every other town you can see is white, black, white, black, white, black. Signs marked whites only or colored, doors, ticket windows, drinking fountains, black and white parks, Oklahoma black and white phone booths. We showed that last week, perhaps you were there and you saw the Coca-Cola black and white machine to sell Cokes. This machine for white customers only. Astonishing in 1950. Prisons, hospitals, orphanages were segregated, as were schools and colleges. And don't get me started on the Supreme Court and the laws about segregation of schools. In one particular case, in medical school, a black man had to sit outside the door in order to listen to the lectures. But this was Mississippi. In North Carolina, black and white students had to use separate sets of textbooks. In Florida, the books couldn't even be stored together. There were 2 Bibles, one for black witnesses, one for white. So one asks oneself, oh no, this is not apartheid. This is, well, what is this? This is a social order whose outlines have been largely erased. The point that I make in Enslaved Washington, D.C. is that even the geography of the town has been archaeologically erased, undone, built under, rebuilt over, but the gentrification is less a question of the gentry is doing this than a question of erasing a very guilty conscience. And it's like statues. I would tell the people where I teach ethics, keep the statues if you want, put them in a museum if you wanted to do that, but change the curriculum. We need to know more about this. Unwritten rules barred blacks from white jobs in New York and kept them out of white stores in Los Angeles. So it's not just the South. Humiliation was about the best treatment blacks who broke such rules could hope for. Gangs and groups like the Ku Klux Klan, which was revived in 1915, used to keep blacks in their place. Or you may be familiar with the paper bag test. If you could pass a certain paper bag color, you could pass. The image I showed very early on of black soldiers in a room. More than 360,000 black men served in World War I. The country welcomed them home with 25 major race events, the most serious in Chicago. White mobs lynched veterans in uniform. If you may have seen the London, what is it? I'm blanking. The London years of the, I'm sorry. That's what I get for talking for 2 hours straight. The Lovecraft Country, where the major character is in fact a black veteran. Black Americans fought back. The National Association for the Advancement of Colored People talks about that. Right. Here are some laws. It shall be, this is the law itself. It shall be unlawful to conduct a restaurant or other place for the serving of food in the city at which white and colored people are served in the same room, unless such white and colored persons are effectively separating by a solid partition extending from the floor upward to a distance of 7 feet or higher. I suppose they're frightened that someone's going to jump over and eat their food. Who knows? And again, if you saw Lovecraft Country, there's an image here with the 2 of them stop at a rural place. All passenger stations in this state operated by any motor transportation company shall have separate waiting rooms or spaces or separate ticket windows for the white and colored races. And you see the image on the left. Sometime Google Rosa Parks and read her story. It wasn't the first time that she'd had a run-in with that particular conductor of the bus, and that was part of the interesting back narrative that maybe 5 or 7 or 8 years previous, he had basically told her that she had to move and get off the bus to go out the door and go back on the bus the proper way. She did. She got off the bus and the bus driver drove away. So her back narrative is interesting on that. It shall be unlawful for any amateur white baseball team to play baseball on any vacant lot or baseball diamond within 2 blocks of a playground devoted to the Negro race. I do not understand. The interesting thing about this is that this is a posed picture. This is a posed image. Okay? Who are these people? What did they think they were serving? And the other interesting thing that I talk about is that why the Daughters of the Confederacy, for example, are the ones that always push the Confederate markers and the Confederate music. I don't believe that women get much of a better shake in terms of gender in this particular culture than other groups. In fact, they get it lots of worse. And so when, as a gay man, for example, I'm asked to kind of straighten up in public, I'm going, is like, well, why should I be doing the work of somebody who takes less care of me than I do myself? And one wonders about, in terms of when you see the images and you see some of these, and we see how who's defending the system, as my cultural friends would say, you know, who's defending patriarchy, and what do we get out of this? Promotion of equality. This is the law that could get people killed in South Carolina. 20 February, by the way, February 1929, a few months before the Great Crash. No dogs, Negroes, Mexicans, El Paso, Texas. Any person who shall be guilty of printing, publishing, or circulating printed, typewritten, written matter, urging or presenting for public acceptance or general information, arguments, suggestions in favor of social equality or intermarriage between whites and Negroes shall be guilty of a misdemeanor, subject to fine and not exceeding $500. Now, in South Carolina, you could be guilty. The slaved person could be killed. Okay, again, another posed shot. This man has what we would call white privilege. He has the power of the law. He has the power to make the law. Okay? He's a white male, not a white woman. Experts agree that the only major distinction between apartheid and Jim Crow is the fact that black people make up a majority. Right? And I have this image here again. Black South Africans and Americans are bound together in a long history of racial segregation. It has not ended. So one looks at this young man and one wonders, where would he have learned all of this? He certainly doesn't get it in school. But there are certainly lessons and playbooks and plans afoot. There is certainly a kind of a shadow university, if you want, shadow schools, shadow education. Whitening up in public, white apartheid in the 20th century. White Americans committed to the myth of black inferiority used law and violent terrorism side by side to establish an apartheid society that relegated black Americans to second-class citizenship and economic exploitation. Again, come back to Nahasi Coates, 95 years of Jim Crow and 3 generations of exploitation through redlining. Why these actions? Why now? So segregation is not Jim Crow. It's apartheid. It includes post-Jim Crow segregation, voting taxes, felony disenfranchising, redlining, gerrymandering, systems of incarceration. There's a white man that I know who's 83 years old who hasn't voted in Virginia for about 40 years because he fell afoul of a felony law that was designed for black persons. And I said, you could go and get this erased. But the man's in such terror of the courts that he won't do it. Okay? In the name of the greatest people that have ever trod this earth, I draw the line in the dust and toss the gauntlet before the feet of tyranny. And I say segregation now, segregation tomorrow, segregation forever. In this state, Alabama, we are committed to segregation by custom and law. We intend to maintain it. My point this evening, it's the both. It's social practice, but it's the law. Important question, what have I done personally to maintain segregation? The Dallas County Citizens Council. You may have been following recently in Georgia, and they have it was in Congress, HR 40 something something, not HR 40, but it was a law that basically authorized Georgia to essentially rent out their convicts to be paid for labor. So convict, this is not a new thing. This was going back in 1860. That convict leasing was a system, actually 1840, system of penal labor practiced in the southern United States, overwhelmingly targeting black American. Convict leasing provided prisoner labor to private parties, such as plantation owners and corporations. We are still doing this. We're calling it about the same thing. The following few slides, again, are simply more information. I know that you've seen the Pierce City Negroes mobbed and around Omaha, wild night under mob rule, Negro burned, mayor hanged. What kind of culture are we making here? And you think about Jefferson again, with his 14-year-old, I don't know which one to call her, and the 5 children that he did not free from her. And we're going to come to the Declaration here in a moment. Okay. Omaha, Minnesota, we're not even going to stay long on that one. Tulsa, 1921. Mobs of white residences deputized by local police. When in 2003 they finally got the state to issue an apology, they were going to give a medal to survivors as a form of recompense. The single worst incident of racial violence in American history. My husband and I were driving down the street here in Washington, D.C. this afternoon, and he said, "Why there's such a long light here at 7th and O Street?" I said, "Well, under a certain different period of time, this was one of the major intersections of town before the riots that ensued after the assassination of Martin Luther King. And all you see now are long empty blocks of places." City ablaze in race war. Is this a race war, or is it simply about equity? May 31st, June 1st, 1921, 100 years ago. James Allen's book, Without Sanctuary, Lynching Photography in America. I'm going to pass over that. The Tuskegee Institute records a figure 3,400 blacks lynched between 1882 and 1950. What is not ever referenced, the fact, is how much these became media events. They would be posted in the newspaper. They would have 10,000, I think I have a slide here a moment ago, that 10,000 persons came to partake in a lynching. In 1892, an astounding 161 Black Americans hanged, shot, beaten, and burned a year. Horrific 10-year period from 1891 to 1901. Okay. More than 100 per year, 1,000 lynchings during this particular period. One person was convicted. One person was convicted. Okay. States of whites: Alabama, Oregon, Mississippi, Virginia, North Carolina, Louisiana, Ohio, District of Columbia, Texas, Arizona. Transitioning from enslavement to legalized white supremacy required a new legal architecture, and during the 80s and 1890s on, Mississippi, South Carolina, Louisiana, other Confederates adopted new legislation and constitutions that denied black people the vote, reflecting segregationist conviction that, quote, "We can trust white people to do right by their inferior race, but we cannot trust the inferior race with power over the white man." 1901, we saw this quote in my first slide. Alabama's Constitutional Convention, quote, "to establish white supremacy in the state." Beginning in the 1890s, Southern states enacted a literacy test, poll tests, elaborate registration systems, and eventually whites-only Democratic Party to exclude black voters. All of this, and I use the example about the National Board for Monitoring Elections makes the point is that they have all manner of federal laws about elections and election safety and this kind of thing. What they cannot protect is states' rights or county rights or what the town is going to do. And A very different analogy is the masking in the policies that a president can make whatever he or she wants to do in terms of she I'm being aspirational, whatever laws they want to make about these. They did it in 1918, and they're doing it now. But local governance has the key about how these are interpreted, whether they actually can work. So the same thing happens here. We have all manner of federal laws around race equity, and we have, as you're seeing, a mess of other laws and practices. And the laws prove very effective, the excluding black voters. And you're seeing that's why it's important when we pay attention to what the current news. In Mississippi, fewer than 9,000 of 150,000 voting age African Americans were registered after 1890. Louisiana, 130 black voters in 1896. Number had become 1,300 by 1904. White primaries, again, very simply, the only way you could become a vote was that you had to go to the white primary itself. Alabama, there's a few slides here about Alabama's constitution is 310,000 words long. It's this huge document, it's the longest document in the world. The purpose of disenfranchising blacks. It is currently, just to kind of keep up to speed, they're currently negotiating now how to take out some of that language. So this is, I think they have voted on it once just recently about removing some of that material. Okay. But this is in 1901. The citizens of Alabama declare for white supremacy and purity of ballot. Montgomery, Alabama, this is the front page. The putrid sewer of Negro suffrage is severed from the body politic of the Commonwealth. 1901. Harangues of disappointed office seekers fail to swerve the electors from their duty to themselves and their posterity. The bulk of the anti-ratification vote cast by the Negroes, but the white men were aroused and worked hard for the adoption of the new instrument. Mississippi, the fourth constitution was adopted in November 1890, mostly Democrats, to prevent the state's African-American citizens from voting. Finally repealed in 1975. This particular document restores white supremacy. The red's important. The 1890 Constitution is credited with restoring white supremacy to Mississippi when Reconstruction after the Civil War brought the vote to blacks by federal mandate. Blacks controlled many public offices in the state. A key provision, is what we've been talking about, in the 1890 Constitution, later adopted by a number of other southern states, provides that in order to vote, a person must be able to read and understand any section of the state constitution. So if you look up grandfather clause, that's where that comes in, that if you could not write because you were, for whatever reason, illiterate, for whatever particular reason, whatever your particular race, because as a matter of fact, the damping down of persons here racially did not only happen to black Americans, it happened also to white Americans, and we get that derogative expression at the other side of the tracks, poor white trash. We get all that kind of language from this. And so what we're talking about in terms of if someone's grandfather could vote, they could vote, even if they couldn't. So among other anti-black provisions, poll tax, separate schools, prohibition of marriage, et cetera, we know all of this. Birmingham, Alabama, probably one of the most segregated cities of the United States. Of 350,000 people, 60% white, 40% black. The 40% black could not take jobs in town. Jobs available to black workers were limited to steel mills, household service, and yard maintenance. The average income for black employees was less than half of white. So racial segregation of public and commercial facilities throughout Jefferson County was legally required, covering all aspects of life as we've seen. And only 10% of the city's black population were registered to vote in 1960. I won't spend much time on these images. We know this. This was the Children's Crusade in Birmingham, Alabama, 1963. Those are fire hoses. As one medical person said, the water coming out of these fire hoses was enough to pull the skin off the bodies. This is Bull O'Connor on the left with dogs attacking a young man, Gibbons was his name, Gibbons. Article 13, the state constitution of Oregon, outlining enslavement and non-white exclusion laws. There's a number of laws in Oregon, as in California. One that says yes or no on enslavement, and yes or no on who can live here and why they can't live over here. That Oregon ratifies its state constitution, 1857, on the popular ballot for the Constitution, 2 other referendum on which citizens were asked to vote. They rejected enslavement but approved adding an exclusion law that became part of the Bill of Rights. The Virginia Constitution, 1902, was an assembly of delegates elected to write the fundamental law of Virginia. And by the way, the 1902 Constitution severely restricted suffrage among blacks and whites when it was proclaimed without submitting it to the people. The license plate, 400th anniversary, 1607 to 2007. And you want to track back to the 1619 and understand that the enslavement in this particular colony went back long before then. And so you have the 400 years anniversary. 2005, Prince Edward County Schools offered recompense and restoration to the students that they had closed their schools in 1967 when they were told by the Supreme Court to desegregate the schools. Virginia County and Virginia, Prince Edward's closed the schools. So Virginia is serious about this stuff. 1874, now at last count, that's 10 years after the Civil War. Journal of the House of Delegates, State of Virginia. Henceforth, let it be understood of all that the political equality of the races is settled, and the social equality of the races is a settled impossibility. Let it be understood of all that any organized attempt on the part of the weaker and relatively diminishing race to dominate domestic governments is the wildest chimera of political insanity. Let each race settle down in final resignation to the lot to which logic of events has inexorably consigned it. North Carolina, again, the Caucasian. Attention, white men, there will be a meeting in the white men of Wilmington. Oh, okay. North Carolina is a white man state. Who will rule it? They will crush the party of Negro domination, et cetera, et cetera, et cetera. So I don't mean to bore you with all this, but this is the Wilmington coup in 1896. It shocks me that we don't have this kind of language in other kinds of places. I find it, as an educator, completely unsettling that the history, that if I were a high school teacher, I'm an American Studies major, so I had all this history coming through American Studies, but none of this. Okay. Opinion, Louisiana, time to strip white supremacy from its constitution. Ohio, California, the new governor, Pete Burnett, didn't include black residents at all. Quote, it could be no favor and no kindness to permit free blacks to settle in the state, he said, while it would be a most serious injury to us. Had they been born here and had acquired rights in consequence, I should not recommend any measure to expel them. The object is to keep them out. Last one, District of Columbia. Why is it that shape? We've talked about this. Alexandria, Virginia, which was the largest slave port in the colonies at the time. When it became clear that the District of Columbia was going to outlaw the buying and selling of enslavement, like they couldn't sell liquor on weekends, they weren't outlawing enslavement, just the buying and selling. Alexandria said, no, we're not doing this. We're going back to Virginia, because as a matter of fact, in 1846, the largest crop in Virginia was not agricultural. It was black bodies on the farms of people like Jefferson and George Washington. Okay. Lakota, Mississippi did not ratify the 13th Amendment until 1995. White supremacy was the motto of the Alabama Democratic Party until 1996. Carry me back, we talked about it. According to the Mississippi Supreme Court, the 1890 Constitution was intended to serve, quote, the broad dominant purpose of preserving the purity and integrity of the white race. And so then we see the America First caucus in 2021, and we go, this is all so shocking and so new and so surprising, and we're saying, have we not been paying any attention to any of this? The color of the law, beginning insofar as we were able to enshrine white supremacy in law. I'm going to take 1 second. I want you to give me just a minute. I'm going to say this, that clearly whatever we are trying to do now with the, quote, American experiment, it has never, even by law, this was intending to be back to 1790. Give me 30 seconds, please.
So Ed's getting close to the end of his presentation. If you have any questions for him, feel free to put those in the Zoom chat or the Q&A. If you joined us late or if you have to drop off, this program is being recorded and will be posted on our YouTube channel a little bit later, either later tonight or tomorrow sometime at the latest, probably. I've previously posted the other programs on this topic that Ed did in the Zoom chat or the Q&A, or you should be able to find it in the event description for where you signed up for this event, or potentially in the email that I sent out that had the links for the Zoom information. So you can keep an eye on that.
Okay, let me launch back into this, and Robert is right. I am coming to the end of this, and there is a lot, and I must say I respect anyone who sits through and tries taking even part of this. And all this material can be found. It's not hidden. It's not brought out a lot. You look at the Declaration of Independence.
We appreciate you delivering it to us, because I can speak for some of the others that this has not surfaced to us before.
You're making it possible to have. The Declaration of Independence, for example, is a document. It's a legal document for the process by which groups of people take up, quote, the separate and equal stations to which the laws of nature and of nature's guide entitle them. If you don't hear the racism there, it's because we don't ever read it there. We always think about Jefferson with his young son Madison, who's playing his servant, writing, we hold these rights to be self-evident. Life, liberty, and the pursuit of happiness. He's not talking human rights. He's talking about the right of one, when in the course of human nature it becomes time for one people to dissolve the bands from another. So he is talking about the separation of one group of persons from another. He is not talking human rights. He's not talking about Sally, the woman he's having. Well, I don't even know how to talk about them without offending myself in saying it. She's the half-wife. She's the half-sister of his legally married wife. And I'm sure Jefferson is not thinking about her either. And there are at least 5 children, one of them who was named after the president, Madison. What were these people thinking? Anyway, in this sense, the phrase evokes two fundamentally disconnected. Separate but equal is a legal doctrine in the United States constitutional law. The phrase is derived from a Louisiana law of 1890. Actually, later on we see this in separate but equal, although the law actually uses the phrase equal but separate. And when you come to the Constitution, we the people, well, by the late 1700s, the slave trade, as they called it, was on the decline. And I don't like to use the expression slave trade because it hides from us, it exculpates the European slavers, including the royal family, who were doing this. And to this particular day, the UK can get away with paying not so much attention to all this, even though Prince Harry basically keeps coming back to the point that they should. That their enslaved was someplace else on some other island, because it was in India in 1606. They were doing this 400 years earlier than ever happened in the colonies. So enslavement was considered immoral by many educated, enlightened politicians in the United States. Slavery and racism, however, are powerful economic advantages, and the reason for the compromised constitution, as I call it, and the reason the text never mentions enslaved or slavery, always talks about persons. It's interesting that they use the word persons. There was never a notion that these were not human beings, and even Jefferson says that. They were human beings, but they were, well, there was something else happening over here. Yeah, money was happening over here. As he himself said, I got 4% compounded interest on breeding my enslavement. He says that. Okay. U.S. capitalist development in New York was built on the enslavement of Africans benefiting northern and southern farmers and traders. A book, how the East or the North profited from continued the slave trade, or words to that effect. I could give Robert the listing on that. The founding fathers, quote, knew that race and racism lay at the economic base of the new country, which is why the North folded as quickly as they did when the question of moving the government from Washington, or from New York to Washington, happened, because they did not have money to pay bills for the Revolutionary War. The Southern plantation owners said, we will pay for it, on the condition that you move the government to the South. So, DC was formed to be a show-off power. It had no representation then for that particular reason, because it was a slaveocracy, and it was designed to keep the people there as enslaved. So I'm sorry for the little speech. The Constitution, same thing that we talked about here earlier before. The citizenship provisions of the 14th Amendment are a repudiation of the most politically divisive cases of the 19th century. Okay. Under common law, free persons born within a state or nation were citizens thereof. In the Dred Scott case, Justice Taney, writing for the court, rules that the rule does not apply to freed slave. And I'm going to paraphrase it here. Really, one ought to read the text itself. The court held that the United States citizenship was enjoyed by only two classes of people. One, white persons born in the U.S. as descendants of, quote, persons who were at the time of the adoption of the Constitution recognized as citizens in the several states, and who became also citizens of this new political body. I'm going to refer back to the Mexico, the people in the former Republic of Mexico that we basically took over in 1848. What happened to those people? The United States of America, and two, those who having been, quote, born outside the dominions of the United States, quote, had migrated thereto and been naturalized therein. That is to say, 1790, First Naturalization Act, free white persons of good standing. Why free white persons? I thought all white persons were free. No, they weren't. And that's a different issue, and we're not going to talk about that here. The court further held that although a state could confer state citizenship upon whomever it chose, it could not make the recipient of such status a citizen of the United States. In less than 15 years later, in 1873, the Supreme Court essentially says this, that the federal citizenship clause in these amendments had nothing to do with state rights. It could not make the recipient of such a status a citizen of the United States. The Negro as an enslaved race was ineligible to attain U.S. citizenship, either from a state or by virtue of birth in the United States. It's an astonishing text. I add here the Corwin Amendment in 1861 because, again, it's not something we ever hear about, but it's also, to be clear, this was in Lincoln's first inaugural address. He suggested that he would support this. And the operative section of the Corwin Amendment states, and by the way, Lincoln did not take any motion on enslavement because he didn't think he had the power as a president. And his own philosophies, as we've seen, tended to be, well, we're going to ship them to Liberia, which had been founded in 1806, as their homeland. And the people to whom he presented this idea basically said to him, this is our home. We have lived here all of our lives. Our grandparents lived here. Oh, right, he says. Okay. Quote, no amendment shall be made to the Constitution which will authorize or give to Congress the power to abolish or interfere within any state with the domestic institutions thereof, including that of persons held to labor or service by the laws of said state. It sounds like Downton Abbey, doesn't it? It's completely whitewashed. The Corwin Amendment, also called the Slavery Amendment, was a constitutional amendment passed by Congress in 1861. But as we know, the states were seceding as it was written. It never ratified by the Constitution. It would have banned a federal government from abolishing the institution of slavery where it existed for all time. It was a last-ditch effort to prevent the looming Civil War. Supporters of the Corwin Amendment hoped that it would prevent the southern states from seceding. In his inaugural address, Lincoln notes that the congressional approval and states that he had, quote, no objection to its being made express and irrevocable. And to the left, you probably can't read it, is a note from Lincoln to the governors of the states, the southern states, telling them that, hoping that they would not secede. March 1st, 1861, March 4th would have been the inauguration date. Lincoln would have been dead in a month after that. Here's where, if you follow the Supreme Court, it gets very unhappy. In the years following the Civil War, 13th Amendment abolishes enslavement, 14th confers citizenship, 15th gives Black Americans the right to vote. In 1875, the most comprehensive civil rights legislation in the nation's history grants all Americans, quote, the full and equal enjoyment of public accommodations. And just 18 years later, 1883, the Supreme Court, by an astonishing 8-1 vote, overturns the Civil Rights Act as unconstitutional and in the process disemboweled the equal protection provisions of the 14th Amendment. And actually, the laws that you want to think about are what they call the Slaughterhouse Laws. So, but in spite, which were between 1873 and 1888, the Supreme Court hands down a series of decisions called the Slaughterhouse Acts that virtually nullified the work of Congress during Reconstruction. Okay. Blacks were separated by law from whites, by private action in transportation, public accommodations, recreational facilities, prisons, armed forces, and schools. Moving pretty quickly because I want to try and bring this to. So the Slaughterhouse cases, 1873, held that the Immunities Clause of the 14th Amendment to the U.S. Constitution only protects the legal rights that are associated with federal citizenship, not those that pertain to state mandate. Okay. 1896, Ferguson, Plessy versus Ferguson, we know this, and that was kind of a send-up case, a lot like some of the abortion cases now, where Plessy was a one-drop person, and it was like Rosa Parks, and she clearly sat where she was sitting, hoping that she would be arrested, and she was. By 1896, the endgame was clearly in view. 6 years earlier, Mississippi had become the first state to drive laws to disenfranchise Black voters. Other states followed. Extra legal methods, aka, we talked about them, we saw the images. Paralegal state-sanctioned violence remained in use. By the end of the century, the work of disenfranchisement was complete. In Virginia, in 1904, the estimated Black turnout in the presidential election was 0. Supreme Court case, we know this, we've talked about Plessy versus Ferguson, the Slaughterhouse cases. I would recommend actually that if you want to take a look at this, because it is a bit the same way that the Supreme Court documents now are working with personal rights around reproduction and genocide and diversity. It should all strike you. There seems to be a lot of biology terms being used over here, but it's all legal. And even the same-sex marriages and other sorts of, quote, personal freedoms come into play here in the way that they are rewriting the laws. Remember that Virginia begins the one-drop law in 1896. It's now confirmed by the Supreme Court. And if you want to see a separate but equal, take a look at some of the schools, for example, in Texas and Florida, up until the turn of the century, and how they were taken care of. Okay. A question I've asked before: when is a person mixed race called white rather than black? And this is what Virginia was doing. We don't care what else you are; you're either white or you're black. Why is this particular person mixed race? Why is he called black? His mother, Ann Dunham, born in Wichita, she's a white woman, and yet, oddly enough, the DNA goes back to one of the earliest indigenous Africans brought into the country. Very quickly, Wilmington to the Proud Boys of January 6th, dismantling the law. How the Nazis were inspired by Jim Crow. And this is Robert will talk about this. I'm doing a larger thing on eugenics and immigration in the United States and their Confederates in the Weimar Republic and the early Nazi regime. To craft legal discrimination, the Third Reich studied the United States, and actually the Supreme Court document was brought into the court in the Nuremberg trials. This slide is in orange because I want it, or yellow because I'm coming to the conclusion, but it's an important one of the main points of Van Woodard's classic study, Strange Career of Jim Crow, 1955, says segregation began in the North, where it was the product not of the practice of enslavement, but of negrophobia. Even in 1835, de Tocqueville, the prejudice of race appears stronger in the states that have abolished enslavement than in those where it still exists. Nowhere is it so intolerant as in those states where servitude has never been known. Okay. When you start thinking about the laws in the North and the places, a whole different, we could do a whole different series on that, but I want to move on here. I want to use this example. The New York Times writes about lynching by white people without using the word white. And you want to look at the picture. This goes back to my point earlier about 3,000 persons lynched, that newspapers would advertise the lynching 3 and 4 days ahead of time. And they would say, thousands of people are anticipated. So here you have a group of persons staring at the camera. Okay. As critics have pointed out, the only time white is used in this article was to describe the women and girls the black men who were lynched were accused of killing or assaulting. Theodore Roosevelt, in an astonishing comment, says the lynchings of black persons will continue until the raping of white women stops. It takes my breath away. So we ask how we got here. A cultural subordination, a cultural landscape designed to perpetuate white supremacy and the racial subordination of black people. And this is the part of the point that I've been making throughout, is that much of the Southern and the national retelling of the history of the Civil War and the Confederacy, and if you take a look at the Southern Poverty Law Center, its map on when the Confederate statues were built, and there are 31 of them across 31 states, and there were only 11 Confederate states, so one wonders what all this was about. But that there were two periods. There were 1890 through 1910, and then 1960 through 1970. And my third question is this: why is it being driven by the daughters of the Confederacy? Is it the men don't have, I don't know, what is it? The men are letting other people do their work for them? I don't get this. Around the turn of the 20th century, white Southerners, men, installed monuments to the Confederacy across the South as part of a concerted effort to redeem the defeat and to retell the narrative. So that what we're doing here this afternoon is recrafting the narrative of the Confederacy and the Bible and whiteness. Because with the Confederacy was born the South's embrace of religion as its moral defense and its motive force. Ministers, generals, leaders, and editors went so far as to proclaim that God had ordained the war and would determine its length, its damages, and its outcome. And for that, I turn you to the second inaugural address of Mr. Lincoln, where he essentially says, as if every debt we owe comes now out in the bond, in the blood of the blonde, in the blood of this particular war, who can say that God's judgments are incorrect? Lincoln's address is a very powerful, short address, but he's making the point that Lincoln himself was calling for reparations then, and basically said that this war has been its reparation, or an estoppel. So we say, well, it can't happen here, and what race has to do with it? Well, this was a 1939 Stop Jewish Domination of Christian America rally in Madison Square Garden. And Robert, I think I am going to end. And I will be here as long as we would like to answer questions.
Awesome. Bravo. Thank you, Edward. Appreciate that. Once again, as always, that was awesome. Fabulous. So let's see if anyone has any questions they would want to pass along to Edward. Feel free to type those in the chat or the Q&A. You have to put those in the chat of the Q&A, or you can put them in the comment section on Facebook. Edward, we already have a few questions came in. First one from Lorana. She asked, why did the Supreme Court declare the Amistad mutineers free in 1841? Given the racial prejudice at the time, why weren't they executed? Supreme Court Judge Tanning declared blacks had no rights
Well,
a few years later.
John Adams, the former president, basically used the Constitution against himself. It says the Constitution says nothing about enslavement. You can't hold these people as slaves. The Constitution doesn't call them slaves. Now, that's a shorthand version, but it's a very good particular question. But John Adams, he was one of the quote, two founding fathers, two of the first presidents who did not hold slaves. And he says, until the last enslaved person is freed, the revolution will not have been won, not complete. But he used the words, he used the kind of the pusillanimousness of the Constitution. They said, you don't talk about enslaved here. These persons are not enslaved. These persons are captive persons from Africa.
That's a great movie that I'm guessing a lot of people either haven't seen before or haven't seen in a long time. We should put that on our list of films we need to stream.
Put it on the list, and then I'll give you a chatter about it. But actually, it's a very smart question because this man is reading the law for what it says and what it does not say. In the Constitution, what I'm calling the compromise Constitution, it doesn't talk about enslavement. But the point is, it talks about, again, persons in service, and has all this circumlocutions, and we should all be ashamed of ourselves for letting all this stuff carry on as if nothing had ever happened to it. The Declaration, the way we think about this. So what we're looking for is a re-narrative. We need to take the American political imaginary that we grew up with and give to our children and say, we need to do better than this.
Okay, excellent. Well, thanks, Lorana. Thanks, Edward. A few people asked about the term "mesti" that you used earlier in the program.
I'm sorry, which one?
Mesti, M-E-S-T-E-E.
There's a couple different versions of the different particular words in each different colony. Mestizo, Mesti, Maroon, so they're mixed race. And it could be mixed race Indigene, it could be mixed race Caribbean, it could be mixed race. So depending on the culture, it's like Creoles, for example.
Okay.
So I do apologize, but if you look up language for mixed race, you'd find all kinds of different expressions.
Okay, no problem. Let's see. Patty was kind enough to point out that tonight on MSNBC at 10 o'clock, they're having a program called The Civil War, which talks about differences north and south about how history is taught. I posted information for that in the Zoom chat. So thank you very much, Patty. Appreciate that. Meredith brought up a point about there were lynchings outside of Washington, D.C. In fact, there were 3 in Montgomery County. There's a great film by director Jay Mallon, who actually, he came and screened the film for us a few months ago, and he's probably going to come back and do it again. I posted the trailer for it on Vimeo. I posted the link. I posted the trailer for the link in the Zoom chat, and he's going to come back and do it again.
I remember my enslaved Washington, where I ended the slaves with sundown towns, and that you look at all the communities of Maryland and Virginia surrounding Washington, D.C., they were all sundown towns by law.
And explain for someone who might have missed that what a sundown town is.
Where legislation existed in law, I should have put that one in here. It's say in Chevy Chase or in what we now call University Park, Huntsville, the various towns, culvert around D.C., there were laws that said you cannot be in this place after dark.
Okay.
So these were that while there were enslaved persons who had more freedoms, for example, in Washington, D.C., they did not have them in Maryland and Virginia.
Okay. Thank you very much for that. Let's see. I don't know what your thoughts are on hypothetical history, but someone inquired about what impact did the death of Lincoln have on race relations, and would things have been better had he not been assassinated?
This person, bless her heart, probably has been reading Harry Turtledove's alternate histories of the United States, which are truly wonderful. But Lincoln is a complicated case, and one ought to hear Frederick Douglass on Lincoln. You can hear my
Like
giving.
it's like that question of would Kennedy have gotten us involved more in Vietnam if he had not? I think it's hard to
Right.
say.
Lincoln changed his mind clearly, but his first there were two what do you call it, Emancipation Proclamations. One was organized in 1862 by a congressman from actually Massachusetts. He signed it because he was president. It was for the district. Okay, and it came with compensation for the owners, not for the enslaved. His Emancipation Proclamation was for military necessity, the same way that Lord Dunham in 1776 had offered colonial enslaved persons freedom in Britain if they came over to the Tory side. So Lincoln is essentially saying, you leave the South, you leave your owners, or how you put it, we will offer you freedom here, which is why you have these wonderful images, St. Faulkner, of the thousands of persons marching behind Sherman's army in the South. He didn't know what to do with them. He didn't know how to feed them, didn't know how to take care of them, which is why Sherman's Field Act 15, which essentially was the first act of reparations, 40 acres and a mule, because he was trying to do something to help these desperate people who were now lured by the promise of freedom and were basically following him along.
Okay. And then let's see, you were talking about the Ku Klux Klan earlier, and about 100 years ago, the Ku Klux Klan was more popular than they are today, even though they're still in existence today, not quite as popular as they were 100 years ago. Is that because the Ku Klux Klan's kind of platform has changed, or is it because maybe people just aren't as into that type of behavior, or a little bit of both?
Well, the first one was basically, a good old boys booga booga, sit around on Friday night, drink beer, get dressed up, and go hunt people. It was really not so threatening. I mean, the cross in Christianity really didn't emerge until after the Confederacy had become late in the turn of the century, in 1899 and 2000, where part of the story of the Confederacy had now been its adoption of Christianity as its moral reason. And so the cross link with KKK is really 20th century. And that was, so the birth of a nation and the third birth of the Ku Klux Klan in 1915 are that. The first one, the second one was during Reconstruction itself, yes, and that's when a variety of other groups, including the Redeemers, including the White Knights, including a group of different persons, became a way of basically organized terror,
Okay.
organized racial terror.
And then let's see, I'm not quite sure what this question was exactly, but I kind of paraphrase it. They're asking about the voting restriction. It seems like those are kind of here to stay for the next short term at least. But what about long term? Do you think 10 years from now, these voting restrictions that are being put in place, will those still be here? Or do you think that is, I guess what we're trying to ask is, with that, is what way is the pendulum going to go? Is it going to keep
I'm
more,
not
we're going to have
happy.
more restrictions or less, or who, no one knows?
I find that I would not try to explain to my children the social environment in which we're lurching in two different directions. You have on one hand, you have the 51st state of Jefferson emerging over in the Northwest. And then on the other hand, you have you have the movement around take down Confederate statues. And so we're still reacting to the past and past narratives. But those who know how to run the government, I'll say Mitch McConnell and others, they are winning. And they're going to, a former president who is essentially telling Republicans, you know what, all elections are defeatist and don't vote in 2022. It's an astonishing statement. But remember that how Nazi Germany, so the link I made before with how Nazi Germany, before they could de-legalize Jewish persons, they had to make monsters out of them. How do we delegalize? How do we use the law against itself? That's our question.
Okay, well, we'll see what happens. Let's see, Edward, I think we've kept you long enough. Greatly appreciate you sharing your insight and knowledge and expertise with us once again. That was fabulous. Again, if someone joined us late, or wants to watch this again, or know anyone else that would be interested, it'll be on our YouTube channel either later tonight or sometime tomorrow. And you can also be on the lookout for Edward's next program, which is going to be in November. Edward, can you tell us about what's coming up in the future?
Well, we have a couple of them. I'm going to take a movement away from this particular. I'm going to be doing something on the first peoples of the United States. And by the way, don't pardon my puppy. He would like to have dinner. He'll get it. So I will be doing something third week of November, I think, Robert, about the first peoples of America, what we would call Indians. At another time when Robert schedules it, I'm going to be doing kind of my own former background in terms of Halloween, Samhain, Guy Fawkes Day, and the history of the indigenous people of Europe, who were, of course, the Celts. So, Robert, all yours.
Okay, thanks. Well, I'll send out the information in that very soon, as soon as Edward and I get those details squared away. Again, thanks so much, everyone, for joining us. Have a great rest of your weekend. Stay safe, and we'll see you next time. Thanks, everyone. Bye.
Thank you, everyone. Thank you, Robert.
No, thank you.